Right out of the gate, we see the courtroom tension already building. Leonard Guillory facing a revocation of his 7-year probation. Keep an eye on how the judge dissects the timeline and charges, because every word here matters.
Good morning. Are you Leonard Guillory? And Mr. Guillory, in clause number 2240982, on probation for unlawful possession of a firearm by a felon, that probation started last June of 2024. It was a 7-year deferred probation. A motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault.
Interesting catch here. There's a mix-up on the vehicle versus on-foot incident. This is a classic example of how small clerical errors can dramatically affect legal proceedings. Ever wonder how much courtroom chaos comes from simple paperwork mistakes?
Assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay. It was with a vehicle. That's at least what the administrative hearing says, but That's okay. Let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in clause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. And the new allegation, printing out real quick the PC, I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response reply to those motions to reduce, and I have reviewed that as well. Give me just It was on foot, yeah. Started on a bicycle. Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
So, ma'am, pardon.
Okay, go ahead.
Judge, as far as these motions, the motion set on motion adjudicated. Of course, the majority of this does deal with this new allegation. As far as the other conditions, raging that you really had, seems that he was going real with that.
Notice how the defense emphasizes work and family stability. This is strategic. Judges often weigh rehabilitation potential when deciding bond. Audience question. Do you think personal responsibility should weigh as heavily as the severity of the alleged crime?
He technically was not working at the time of the offense. He had basically workload with a layoff because they have been called back to come back to work. He's trying to be able to bond out and get back to work. Obviously, he can hire his own attorney and we could take care of his bills, things like that. Go through the process, go through the case. So he definitely would like that opportunity if I have a bond set on with the NPRP. As far as the new case, the ag assault, understandably, is a serious offense. We are asking for a reduction in maybe in incorporating some bond conditions that may secure any of the court concerns of public or private safety to for plain witness or the general public while dealing with it. We to include the full GPS monitoring with with a curfew would allow them to be able to work back home. These people take care of these things. With his job, he would be able to for the monitoring and GPS monitoring. He does have some support, family support. His wife is here today, and has been here each time before he was coming to court. Uh, so that's what we ask the judge. If, if we can get a bond that is over 200,000, bond that I a lot of bonds in the courts. So they a lot of want him to take. So
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
as far as I know, it hasn't been accepted or been going forward on that. My understanding. So the main issues that we were dealing with is forcible cheating.
Obviously, that one is also important to me because that would be another felony allegation while he's on his probation. Let me see if the administrative hearing has any information on this. So when the administrative hearings are scanned in, I've noticed some of them it'll say see attached narrative or PC or something, and those are not always scanned in. Are you looking at the court copy? It'll say court copy. Okay, so the court copy. Court copy. Gotcha. No, that's perfect. That's what I needed. Give me a second. Not sure. So, for the record, I'm taking judicial notice again of all of the court's files attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offense of burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So,
Whoa, this part is intense. Erratic behavior, possible intoxicants, mental health concerns. This isn't just a procedural matter anymore. This highlights how courts balance public safety against the defendant's personal struggles. It's a delicate dance.
this is allegedly a neighbor where the allegation is that Mr. Guillory got in their car, tried to start it, and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, you said this is an episode where he was under some type of psychosis, dealing with mental health, and checks himself in.
So obviously I need that information, because I don't feel like if that's going on that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me.
And here it comes. The judge denies bond based on the combined weight of allegations. Key takeaway: prior felonies plus current allegations can tip the scales decisively. This is a textbook illustration of how multiple factors converge in judicial decision-making.
Based on all of the allegations in the motion, as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful possession of a firearm by a felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on all of that information, under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know. We'll get someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff. And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April.
Quick pivot: missed court dates and bond forfeitures. This is a reminder that procedural compliance isn't just paperwork, it's survival. One slip and the consequences escalate fast. Think about it. How would you keep track of all this if you were the defendant?